Good morning, everyone. We'll get started in just about 10 minutes here. Hey, Jennifer, it's Garrett.
Hi, how are you?
Good, good. I think just so you're aware, I think everyone, all the participants can hear us right now, but I've got a good audio, and I'll just come to you once we get started.
Okay, sounds good.
Thanks a lot.
Thanks.
We were last week saying it was changing day by day, but we've updated that to changing hour by hour. And if you've looked at the news today, from a legal standpoint, last night, Congress, the Senate sent to the president, and the president signed an important statute that's called the Families First Coronavirus Response Act. And I have worked with Tricia Riley from Murtha, and the two of us are prepared to walk through that brand new statute, obviously with the caveat that we are all reading it kind of for the first time, and there are many unanswered questions. But before I turn to that new statute, which will make a difference in your planning and what you must do with respect to sick time, with respect to paid leave, and some updates on unemployment, and I'll come to that in just a moment. I also want to point out that I, with my group at Carmody, our labor team, and I know that's true from other firms such as Murtha, and Trish will say the same thing in a few minutes, we have been working kind of around the clock. We've been inundated with many, many requests, and we've been on the phone constantly to address many issues, some of which are in this new statute, and a little bit later we'll hit some of the others, but the key areas are things like unemployment, wage and hour, the effect on privacy laws, discrimination, and we have a very long list and can provide additional resources. So by way of introduction, there are many things that we could spend several hours on, and Tricia and I will try to give an overview, and then with Jennifer joining us as well, we welcome, sort of the practical approach, what's happening at Marrakesh in her role as a senior VP leader in an organization, in a nonprofit organization. So with that, Garrett, what I would do is start with just a brief overview of what the new statute that the president signed. I'm going to do an overview, and then I'm going to turn it over to Tricia to summarize some of the key things that employers need to know. Does that work for you? Great. All right. So as I said, this bill was only introduced on March 11, and now we're at March 19. And so what happens, it was remarkably fast. But as you'll hear us talk about, in some ways, it's already too slow and behind the times. It's already kind of 2 weeks too late. But here's what it provides. A number of areas. It addresses things that are non-human resources, such as the SNAP program, emergency food assistance, nutrition grants. I'm not going to spend time on those. It also suspends certain requirements and starts addressing Medicaid-related assistance, makes some changes on that. From an employer perspective, though, what it makes a change to is it establishes a federal emergency paid leave benefits program to provide payments to employees taking unpaid leave. in effect, a paid FMLA. It also establishes requirements to provide paid sick leave to employees, and Tricia will talk about those in just a moment. But you should know, from a big picture perspective, it expands unemployment benefits and provides grants to states for processing and paying claims. And you'll see that it is likely that the time period under which employees can receive unemployment, which is typically limited to 26 weeks, can now be expanded to a year. And there's significant funding, I believe it's $1 billion, going into the unemployment sector. This new law also establishes requirements for providing coronavirus diagnostic testing at no cost to consumers. And finally, I would note that it treats personal respiratory protective devices as covered countermeasures that are eligible for certain liability protection. So, in other words, the statute is fairly comprehensive. If you want to find the statute, it is House Representative Bill 6201. And if you go on congress.gov, you can find a summary as well as you can find the actual text of the law. But at this point, I think it makes sense for us to focus the conversation on the human resources concerns. And at this point, what I would do is ask Tricia if you would continue and talk about the paid sick leave components of the new law, as well as the paid family medical leave act laws, the changes. I would say to you, it's very important that this statute does not change the existing family medical leave obligations or paid sick leave obligations. So I'll stop at this point and turn it over to Tricia.
Tricia? Let me unmute you.
I'm having some difficulty.
Okay, there you are.
Thank you, Chuck. Thank you, Chuck. Can everyone hear me? I'm having difficulty with the audio on this, so I had to call in. Can everyone hear me?
Yep, that's good.
Okay, good. Okay. So let's get into the details with regard to the Families First Coronavirus Relief Act, which expands family and medical leave and mandates sick leave pay. And I just have to thank my colleagues at Merthyr Kalina, Jamie Radke, Salvador Gangemi, and Matt Curtin, who stayed up with me till 11:30 last night, trying to wrap our arms around this this new and sweeping legislation. So, from a high level, as to reiterate what Chuck said, the act requires private insurance plans to provide free COVID-19 testing. It requires employers to provide emergency paid sick leave to workers affected by COVID-19 and expands family and medical leave. And it provides increased funding for state unemployment insurance programs, food stamp and nutritional programs, and other programs. So, first of all, the effective date. The effective date is 15 days after the enactment of the bill and ending on December 31st, 2020. So this goes through the end of this year. It starts on April 2nd. It's a Thursday. April 2nd is 15 days after the enactment. So it starts on Thursday, April 2nd. That's a critical date, so everyone should be aware of that date. Okay, what are the specifics? The specifics is it expands current FMLA significantly. As we all know, FMLA usually applies only to private sector employers with 50 or more employees, as well as public agencies, regardless of the number of employees that they employ. But the Act expands FMLA benefits to all private sector employers, in other words, as a covered employer with fewer than 50 employees. So let me reiterate, often we're used to hearing, oh, if you have more than 50, FMLA applies. That is not the case. For this new act, if you are an employer with fewer than 500 employees, you must comply with this new Paid Family Medical Leave Act. If you have fewer than 50, you must comply as well. An eligible employee under this new law is anyone who's been employed for at least 30 calendar days, okay? So we know that's extremely different from the usual FMLA. So what are the threshold levels again? Under 500, and for the employer and for the employee, 30 calendar days. Okay. Now, the FMLA is somewhat limited in what it will extend to. The Act identifies a new reason for eligible employees to take job-protected FMLA. Specifically, eligible employees who are unable to work may take leave for the purposes of caring for a child under the age of 18 years of age whose school or child care provider has been closed or is unavailable because of the COVID-19 emergency. Okay, what are the benefits? The first 10 days of this expanded FMLA will be unpaid, although employees can use paid time off or sick time to cover some or all of the initial unpaid period. After 10 days, the employer will be obligated to pay full-time employees 2/3 of their regular rate or pay for the employee's regular weekly hours for up to 10 weeks. Okay, I'm not going to go into the specifics for part-time pay, but know that the law is specifies how much to pay for employees. Do keep in mind, this is for essentially for childcare, this expansion. So this is somewhat limited in how it will be applied. If you are a small business with fewer than 50 employees and you can show that compliance with this law would jeopardize your business as a going concern, meaning almost bankrupt you basically, then you can apply for an exemption. Otherwise, you need to comply with this law. I can tell you that both Chuck's firm, Carmody and Torrance, and mine are putting out guidance on this today. So you can look on our website. I know there's a lot of publicity on this because it's so new and everybody's trying to wrap their heads around it. But the FMLA expansion is somewhat limited because it goes to the child care. The Emergency Paid Sick Leave Act is more comprehensive and is likely to impact more businesses. Here's why. It will require all employers with fewer than 500 employees to provide full-time employees with 80 hours, prorated for part-time employees, of paid sick time. This paid sick time is in addition to any sick leave already provided by the employer. It will not carry over to the following year. The employer must permit the employee to use paid sick time discussed in this section to cover the initial 10-day period of unpaid leave under the FMLA, which was above. So what are the reasons an employee may be able to take paid sick time? 1, the employee is subject to federal, state, or local quarantine or isolation order related to COVID-19. 2, so that means New York, anybody living in New York City, for example, who's under local quarantine, isolation. Number 2, the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. This is a big category of people. So you can call your healthcare provider if you're having any symptoms. The healthcare provider can say that you need to self-quarantine because you're showing some symptoms, and that automatically entitles the employee to this 80 days of 80 hours of paid sick leave. Next category, the employees experience symptoms of COVID-19 and seeking a medical diagnosis. Note that this category does not say has a diagnosis, it's seeking. So basically, in my view, if someone says, I have a sore throat, I have a cost. I'm going to the doctor. I'm taking the day off from work. This sick leave kicks in under that category. Number 4, an employee is caring for an individual who is subject to an order as described in paragraph 1 or has been advised as in number 2 above, bullet point 2 above. So you're caring for an individual who has symptoms and needs to go to the doctor or has already been told to self-quarantine. Next is the employee is caring for a son or daughter of such employee if the school or place of care of the son or daughter has been closed or the child care provider of the son and daughter is unavailable due to COVID-19 precautions. Okay. Number 6, the employee is experiencing any other substantially similar condition specified by the Secretary of Health and Human Services in consultation with the Secretary of the Treasury and the Secretary of Labor. What exactly does that mean? I'm sure that we will get more guidance on that. But basically, I think what this sick leave is intended to do is that if you have someone with symptoms and they're self-quarantining and they tell you, I'm going to get help from my doctor, I'm in touch with my doctor, that's sufficient to trigger this law. So what are the paid benefits? The emergency paid leave benefits. Full-time employees will receive paid leave at their full regular rate for the first 3 reasons above and 2/3 of their regular rate for the 4th and 5th reasons. Without slides, I know it's hard to follow this, and so therefore, I think that, as I said earlier, you can go online and get these summaries, both from my firm and from Chuck's, and once they're finalized, I think if we need to provide that through the chamber, we'll arrange with Garrett to do so. So there are basically how to pay these employees are embedded into these acts. Also note that the new federal paid sick leave provisions do not preempt state paid sick leave laws, such as Connecticut's paid sick leave. So you have to comply with that as well. So these new laws are on top of that. They do not diminish an employee's existing rights under a collective bargaining agreement or existing employer policy. This is going to have a huge financial impact to employers, and therefore employers will be entitled to a tax credit. But I'm sure employers are asking, well, what if we can't make it to the tax credit? And I think that is a big issue. Chuck?
Yes, I would just add a couple of points to what Tricia said. It is important to realize that there is a tax credit, and I do understand that it will be done on the calendar quarter. So I would make that point. But the other point that I think is very important, Tricia mentioned, and usually when you have an effective date of a statute, it is what it is. But here, it actually matters. That what the effective date says is that it's effective not later than 15 days after it's enacted. And this law also sunsets on December 31st of this year. Why that date matters of 15 days, as Tricia said, is April 2. Although it's passed, it's not in effect yet. And one of the main issues, a big issue that we are dealing with lots of our clients, and I know Tricia is doing the same thing, is if an employer has followed some of the suggestions, such as Mayor Elliker has done, continues to ask businesses to close, if a business has already closed and its employees are not working, what those employees can do is file for unemployment. What they get is unemployment. And Tricia will say a little bit more about the unemployment processes in a second. But why it's important is that if if your business is already closed or you have laid off people, if you go to the reasons that Tricia just talked about with respect to the paid sick leave, none of them applies. So the paid sick leave would not be required in a business that is closed. And this creates some confusion, and admittedly, there are still some quirks in seeing how these things fit together, because as I'm sure you recognize, that if a person is entitled to paid sick time under this new law, they can get up to 80 hours of their regular pay. If a person claims unemployment, they are getting a percentage of their pay depending on their salaries and their income level. And so the effect is that there is a difference between people who qualify for the required paid sick leave. Now, it is balanced also, however, by the fact that unemployment you can get for a much longer period of time, albeit at a lower rate. Why I bring this up is that one of the major issues that we are dealing with in counseling employers is how to deal with layoffs, when to do layoffs, which groups of people should be laid off or can be laid off, what's the effect of remote working, and can a person, can the person get unemployment at that stage? But I want to call to your attention that because this new statute is not in effect yet, anyone who makes a decision to close a business, say today, the employees would go to unemployment for the most part, rather than this paid act. And that's kind of a quirk that we're all trying to work through, and encourage you to continue to watch for further guidance on that point. Tricia, maybe you want to say a little bit more about the unemployment piece. And
Yeah, I mean, I'm just going to say with regard, oh, yeah.
Yeah,
Okay,
let me,
okay.
I do want to bring Jennifer Falzone from Marrakesh in too, and we'll keep this discussion going on the legislation. So maybe Tricia, if you just want to wrap up on some of the legislation, I know we'll get back to it with the question and answer, and then we'll give Jennifer a few moments to talk, and then we'll just open it up to everyone's questions and answers.
Just following up on a point that Chuck made, what's interesting to me is I have not seen an anti-retaliation statute provision under this new law. Most of our laws, as we know, say you can't lay. Is there? Okay, let's talk about that. So So I hadn't looked at that yet. So
yes.
So if there's
I'm
an
sorry to interrupt, but
anti-retaliation,
there is an anti-retaliation.
Okay, I'm glad you did.
provision.
I'm glad you did. So then let's talk about that. So is it the case that if an employer lays everybody off in anticipation of not wanting to pay the 80-hour sick leave provision, is that illegal under the Act? In other words, if I'm an employer and I'm saying I cannot afford this, it's going to bankrupt me, therefore I need to do layoffs now because I cannot afford to pay my entire staff for the 80 hours of paid sick leave, is that the kind of anti-retaliation provision that you're seeing? Or should we say,
yes, Tricia.
Yeah, okay.
Sorry to interrupt, but the law does
Yep.
include an anti-retaliation protection for employees and provides that the failure to pay sick pay would be treated as a violation of or treated the same as a violation to failure to pay minimum wages. So that
Okay.
does exist there.
Right. So if people are making decisions now, looking at their budgets and saying, I need to lay off a certain percentage of employees because I can see that I'm not going to be able to afford to pay, potentially sick leave to people who remain, that in and of itself is not illegal right now under this new law. Is that what you're seeing? In other words, people may be planning right now and saying, yesterday, before this law was passed, I was going to lay off 10% of my workforce, and I was going to do it as of Friday. Can I still do that?
Uh,
That's, I
we
think,
are-
the question if we don't, yeah.
Yeah, I understand the question. You know, in terms of advice to employers as you're learning about this bill, I think it's important to note that there are some quirks about when this takes effect, but we are still suggesting that each business consider its own circumstances and what the governor and what the other public officials such as Mayor Elicker are recommending and driving the decision based on those considerations and your business needs. There are these legal provisions in there, but I think at the first stage, we've got to do what's right for employees. And so it does have this effect, but in either event, from the big picture, what I think the takeaway is that employees will either be able to collect unemployment, and then if they meet these 6 specific reasons for sick leave, they would be able to get this required new benefit of up to 80 hours. So it is I think there are a number of issues, and it's a little bit quirky, but there are a number of issues that we'll continue to work through. And as you said, there are resources listed on both of our websites to help people navigate and see this in writing.
So let me pause right there. Sorry, I've been joined by my assistant, but we'll have, let me have Jennifer speak for a moment. And while Jennifer's talking, I know there's a lot of detail that we just put out between Trisha and Chuck. So there is a Q&A button, or you can go into the chat. You know, please enter your questions there. Trisha and Chuck will start taking a look at them. I'll also read them once we hear from Jennifer, and we'll start going through some of those questions that people have. But I'm going to unmute Jennifer right now. And Jennifer, you know, why don't you just tell us from at Marrakesh, what are some of the issues that you're dealing with, and how have you guys been navigating?
So, you know, this is obviously uncharted territory for a lot of our biggest concerns that we got when this first came out from our staff was, you know, questions about, does it fall under workers' comp and how are they going to get paid for work? So we've kind of addressed those. We have kind of a core group of employees that are, I guess, disseminating all the information to the staff to make sure that we give them everything that's as accurate and as timely as possible, since things are changing day by day, and sometimes, you know, things that the way things were in the morning are not the way they are by the end of the workday. So we're trying to make sure we get that communication out to staff as much as possible. We had, you know, we're putting things in place like limiting how many people are in the office and canceling non-essential meetings and other meetings that we're doing virtually, just so that we can make sure that we're distancing people as much as possible. And really just trying to answer everybody's questions. People have a lot of questions, employees have a lot of questions. You know, we have a lot of things that we have to figure out before we can give them that information. So just really making sure that we're communicating as often as we can and as accurately as we can to our employees.
All right, thanks, Jennifer. I appreciate it. And so I'm going to start going through some of these questions, and I'll unmute all of our panelists so that they can speak. And so let me start with the first one. What about employees to care for elder parents? Does this include 501c nonprofit?
I can address part of that question. Our view, meaning my firm's view of the new statute, is that it does apply to nonprofits. Nonprofit status doesn't change the applicability of these required benefits. One thing I would note that nonprofits do have the opportunity under the unemployment system to pay, rather than pay a tax, they can pay what's called dollar for dollar. And that may have an impact on nonprofits' finances because of the unemployment that we just talked about. It's not the same equal trade-off. With respect to the question about what about employees to care for elder parents, my reading, and Tricia, I would look to you on this, but in terms of the required sick leave, one of the reasons is an employee is caring for an individual who is subject to a quarantine or who has been advised to self-quarantine. You know, you might, it doesn't specifically call out caring for an elder parent. One of the requirements does say caring for a child of such employee, but presuming that the elder parent has been advised to either quarantine, which there are many such orders, my guess is that that would count as a reason for sick leave. Let me say just broadly as well, given the current environment, I would expect that these guidelines would probably be interpreted pretty broadly, and I would encourage employers as they view them not to parse it too carefully given the state of the economy, given the state of people's mindset. You know, we have an anxious world these days, and particularly anxious employees. And so we are advising employers to tread carefully as far as restricting benefits. Tricia, maybe you want to.
And Chuck, I would underscore that by saying the fourth bullet point, the paragraph number 4 is the employee is caring for an individual who is subject to an order as described in paragraph 1 or 2, and 1 and 2 are the employee is subject to a federal, state, or local quarantine or isolation order, or the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. I can tell you, so an individual is very broad. So that means anybody. It doesn't even say a close family member. So if you have somebody, if you have an employee who is the primary caregiver of an elderly parent who has been told by their healthcare provider to self-quarantine due to concerns, then that person would be covered under the Paid Sick Time Leave Act. And I have to tell you that, you know, this idea of getting the advice by a healthcare provider, it doesn't say you have to have a doctor's note. It says, if I call you up and say my mother's doctor says that she needs to quarantine because she has an underlying medical condition that makes her more susceptible, and I have to be with her to care for her, I would say you need to provide that employee with the sick leave. I would also say that you need to, this is consistent with other guidance we've read, you need to be somewhat flexible on these doctor's notes to the extent doctors are being overwhelmed with requests for documentation. It may be more difficult for employees to get doctor's notes. And to Chuck's point, I think employers need to be flexible in this regard and not rigid, because that's the whole point of all of these laws, is to support employees during this time and not stick to overly rigid rules that are going to impede employees' ability to care for themselves and family members or whomever they are primarily responsible for.
Let me jump in for a second. So a lot of questions about the shared work program as it relates to unemployment. What can you tell us about this, or explain that a little bit more?
Tricia, can you address that one, please?
I have to say I'm not personally up to speed right now on the shared work program in the context of COVID-19. What I'm finding more is employers are deciding that they have to lay off employees, and I can tell you that the website is set up very in a very user-friendly way. There's a link immediately to the coronavirus. If you are unemployed due to coronavirus, If your hours are cut by your employer significantly by 50%, I don't know what the exact percentage is, but if your salary or wages have been cut significantly, you're also able to apply for unemployment. The unemployment website indicates how to answer the questions, and the first question is, do you have a job in the future, or words to that effect, do you expect to be re-employed? And everyone is advised to answer yes if you've been laid off due to COVID. So the point is that to me, it appears that the Connecticut Department of Labor is treating everybody who gets laid off under these circumstances as a person who may have their job back when this is over, whether that is true or not. And by answering the question yes, it's going to expedite people's receipt of unemployment benefits when they've been laid off due to this. I had experience with the shared work program with regard to the 2008 recession. I'm not sure that I haven't had any direct experience with it right now in this context. So we can maybe get back to that person directly if you want to provide Garrett with your information, and we can look into that.
Tricia, I can add that I've had a little experience, like you say, it was a very robust program in the 2008 timeframe, but just broadly, it does allow people to, in effect, share a job. And we have been counseling some employers who are having their workforce continue, but doing it on sort of alternate days or a rotating schedule, so as to keep people working. And many of them are still providing full pay or benefits, and they're continuing that at least temporarily. And what is important is that if the employer says, you can work these 3 days, whether it's in a shared work program or not, it provides for unemployment. People can collect unemployment for partial work weeks. And so that's not exactly the shared work requirement, but what I do recommend is you go on to the DOL website, and as Tricia said, there are links. I will tell you that we are familiar that there are just an overwhelming number of people applying for unemployment. It's in the tens of thousands already. And so, I don't know how much direct contact you're going to get, but their website is set up and they are prepared to address things like shared work and other ways to make it efficient for employees to apply for unemployment without too much delay.
Let me throw out another question. I'll just read this from Kim Pedrick. Where a retail shop temporarily closed, do I officially need to lay off employees, or any protocols that I should be following in these circumstances?
So I can address this one, Chuck and Garrett. So if your retail location is closed, those employees can all apply for unemployment. And the only thing, you don't need to give them anything. You can just tell them they can go on the website. If you want to give them the website address, you can do so. But if they just Google Connecticut Department of Labor or Connecticut Unemployment, they should be able to find the website. What they do need when they complete the online form, they don't need anything from their employer. They just need to represent that they've been laid off due to coronavirus. Their location is closed. And what they do need is your employer ID number. So if you know that and you can get it to them by email, that would be helpful. But even if the employee does not have the employer ID number, the Department of Labor will process the claim and it will provide the employer ID number. It probably slows the process down if they don't have it. Now, all of this assumes that, your retail location, I'm not going to get into the WARN Act or anything like that. This is for your individual employees who have just lost jobs. And we know there are many of them. And so if that's the case, they can go to the Department of Labor in Connecticut, the website, apply for the unemployment benefits, and get them processed on emergent basis, although to Chuck's point, I don't know how quickly they're processing them given that they're overwhelmed, but that is the step they should take. I don't know if Jennifer or Chuck, if you have anything to add to that.
I would like to add to that, and this applies sort of generally to businesses that have laid off people. We've gotten this question a lot, whether it's a furlough, whether it's a layoff, and this doesn't just relate to retail shops, is that as you're thinking of laying off people, remember to check your policies, or if you have a unionized environment, make certain that you are checking your union contract and or negotiating with your union about these matters. The fact that these are emergency situations caused by the coronavirus, and many places are shutting down, does not mean that you can ignore provisions in your employee handbook or in your policies. For example, if you give people notice and say that you are going to pay people, in some cases you've got to be careful to comply with those policies. In other words, look to see if you have addressed this, or you have severance requirements. Make certain that you don't have a situation where someone's going to come back and say you didn't follow that under your own policies.
Let me ask this next question. I'll send this to Jennifer first, and because maybe you're dealing with a similar situation. A person says, I have 2 employees who have advised us they are not returning to work due to fear of sickness.
Mm-hmm.
How are you dealing with this? And then we can see if the new provisions, how they address it.
Right. So we have had that come up actually just in the last couple of days. That's the first time that's come up. So we've been able to, up till then, even if programs close, provide other hours for people to work. But we do have a couple of people. So we do ask some underlying questions, do they have a health issue or something like that? If so, then, we are sensitive to that and allowing people to stay home. If sometimes we had someone who was uncomfortable being in one program, but then we were able to switch that person to a different program so they were more comfortable working there. So we're just trying to kind of be open to that, but also working with the employee to try and come with a compromise, because we do work with people who our staff are essential and they do need their staff to come in. So, we are trying to work out how we're going to deal with that as far as people taking PTO time, or do they take it with time off without pay, and that kind of thing. So this just came up in the last couple of days, so we're still trying to firm that up. But it is important that at this time, we're a little bit more sensitive to employees and how they're feeling with all of this, because it is causing a lot of anxiety and fear in people.
If I might add to that, Jennifer, I agree with you. This is a hot issue. We've had this a number of times as well, and the thing that we noted in this new statute, as Tricia went through, is that there's not a provision for this paid sick leave for someone who just decides on his or her own to stay home. If a person says, I am afraid and I don't want to come to work, but they have not been advised by a health provider to quarantine, or they are not experiencing symptoms, that person does not qualify for those benefits. Now, that's the technical legal answer. As we've said, and Tricia and I have both said a couple of different ways, that we think, given the level of anxiety in the workplace, given the effect on morale on the rest of your employees, we are cautioning people to read that too narrowly, because people are afraid, and so I think your approach, Jennifer, to evaluate what benefits that you would provide is the right one, and do it in a way that is, at least in these times until we're through the height of this crisis to be liberal in applying that.
Okay, let me get in a few more. Had a question here. Under the new statute, how does an employer apply for the tax credit if they comply with the 80 hours of paid sick leave?
My answer is we'll get back to you on that one. Chuck, I don't know if you know the answer to that yet.
Well, I have seen the statute on it, not enough to sort of reply on the absolute detail, but what I do know that the tax credit will be allowed against the employer portion of the Social Security taxes. And I believe it's going to be done on a quarterly basis, so that when you are preparing, or your accountant or your financial office is preparing that, I believe that any of these amounts that are paid for the paid sick leave or the paid FMLA required by this new statute during this year, they will be credited at the time that the employment taxes are owed. That is the FICA Social Security taxes that are owed on the quarter. And if in fact that you have overpaid, meaning you have done more sick leave than what your Social Security obligations would be, the statute specifically allows for the excess credit to be refundable to the employer. The thing though to note is that this sick pay or FMLA pay do not count for wages for purposes of the employer portion of the FICA. Again, that we could spend a lot of time on that, and Garrett, we should probably move on, but that's another area where people may need to follow up, and we can provide additional detail.
Okay, let me throw this one out there. Do the periods of leave under each act run concurrently? Can an employee run them concurrently?
I don't read it to run concurrently. I think they're separate, non-concurrent entitlements. Chuck, do you have a view?
I agree. So that if you take a FMLA leave under this new act, it's not like you're going to take 12 weeks here and then get another 12 weeks under the federal law. Do you agree, Tricia?
Well, I think that the idea is that on the paid FMLA, that's a paid period of time. So you think it diminishes the total amount of 12, that it does count toward the 12 weeks of leave?
I don't think that you can take an additional. I think it counts as that, although
Okay.
it is not absolutely clear. I mean, obviously there's no cases looking at that, but that is my
Right.
understanding.
Okay, let me jump to the next one, and I'll pose this to Jennifer, and then we'll get our attorneys to weigh in. We are a supply chain business. Can you incentivize those who decide to continue to work? And I guess, Jennifer, I throw that to you just based off of knowing that you have essential employees. Has this thought even come up about ways to get people in?
So far, no. We haven't had any discussions about doing that. We have done a few slight changes. So if we have like a perfect attendance program that we have with staff. So if they have to be out and have to use time off without pay specifically due to this, we've kind of not counted it towards that perfect attendance benefit. But other than that, we haven't really talked about any other incentive programs for people coming to work at this point.
Chuck or Tricia, anything you want to say on that?
I don't think there would be anything illegal about doing it, incentivizing people. I think you want to be careful about the practical effects of that, and the morale, and there's a quote battle pay kind of aspect of that. But I'm not aware of many companies that have begun that process.
Okay.
I agree. I mean, you could think of it as, there have always been shift differentials for shifts that are more difficult. People don't want to, work on those shifts. You have to be cognizant that if you are providing bonus pay or any kind of increased pay, it's going to affect the regular rate for purposes of paying all of these leave entitlements that have just been passed. Some of them are based on the employee's regular rate. So I see no downside to your business of providing incentives if you wish to do so. Most of the calls that I'm fielding are on the opposite side of, concerns about not having sufficient amounts to pay employees and having to lay people off. So if the issue is incentivizing, I think, however, you can do that and still ensure that your workplace is as safe as possible under these conditions, you can go ahead and do so.
We're getting close to the end of our time. And if people still have questions, you can send them to us. We'll try to answer those, get that information out. We are recording this, so we hope to have the webinar up shortly later today or by first thing tomorrow. Let me throw out a kind of different question than what we've been talking about. For employers who have been sending their employees home to work remotely from home, Jennifer, to you, but then also to our attorneys, any issues that are coming up? I can just say at the chamber, I mean, obviously when you're trying to manage an organization and people are in 16 different locations, it's a much different situation than what you have at the workplace.
Right. So we have been doing that. We have been asking everybody who can work from home to work from home to reduce the number of people that we have in our different program sites. So far, it hasn't really been too much of an issue. We do have a virtual meeting software, so we've still been able to connect with people, have sort of face-to-face meetings virtually that way. We have new, contact numbers for people who are working from home, and we've sent all those out to people, forwarding our phone to our cell phone so that we have that continuity, so we're still able to get phone calls. So so far it's been okay. It's for those of us working from home, we don't have access to quickly print this or mail this or that kind of thing, so it's working out those kind of small logistics. But other than that, there hasn't been really any huge roadblocks to that.
If I might add to the remote question, one suggestion that we are advising clients on is the cybersecurity of that. If you're having people work remotely, make certain that your systems are secure. And we put out some specific requirements and suggestions, including if people are working at home, that you tell them, it's kind of funny, but you tell them, make sure you turn Alexa off so that you're not having this call and Alexa is either recording it or you're getting Amazon tied into it as well. So it's sort of a little bit funny, but there are some concerns. And I know we've said it several times, we have a specific piece on guidance for working at home and the things to be concerned about with respect to cybersecurity. And you can find that on our website. And I know Trisha's got the similar write-ups. All of the emails, and we've probably written a half dozen of them that provide guidance, are available on the top of our website. It's www.carmodylaw.com. And Trisha's got the same kind of, so you can find resources. And also, probably more importantly, we have compiled a list of resources for the Department of Labor, Unemployment, Connecticut.gov, the IRS, EEOC, the small business. And maybe Garrett, a question for you on the small business. I know that there's some new announcements. It's not the law yet, but there are some proposals to provide for small business loans, and I know the Chamber's been doing some work with that as well.
Tricia, anything you want to add, and we'll wrap up here.
Yeah, just on the work at home piece, keep in mind the rules regarding non-exempt and exempt employees still apply. So if you have non-exempt hourly employees working from home, make sure they're recording their hours and getting their lunch break. They're still non-exempt employees under the FLSA and state law. And Garrett, just following up on Chuck's point, I sent you the link to the blog post that we have published, from which I took the remarks today with regard to the new law, so that you can distribute in whatever way you wish to the members. And I'm sure Chuck can provide you with links to his resources as well.
Great. Well, I want to thank all three of our panelists. I want to thank the HR Council as well. We have Glenn Archer, who is our staff liaison for the HR Council. And we actually had several more people on the HR Council who are willing to present. So we will be doing those additional webinars over the coming days and weeks. Thank you to everyone who joined us. I know it's a really difficult time for all of our businesses. And so at the Chamber, we're just trying to push this information out as much as we can. As I mentioned, we will put the recording of this webinar onto our website, and additional questions that come in, we will try to answer those and get a question and answer sheet up on the website as well, and the resources that have been mentioned here on the webinar. So again, everyone stay safe, and thank you for your time today.
Thanks, Garrett.
Garrett.